All right, everybody, welcome back to the channel. This is a continuation on the subject of citizenship. The first one was on, of course, law books on the topic of citizenship. Today will be a law journal of citizenship, specifically the terms subject, citizen, national, and permanent allegiance. It's about a 20-page PDF. There will be a part 3, and it'll probably be a reading of this book, which is 52 pages, so I don't know if I'll read it all, then perhaps the pertinent parts. And then this one. This is the military training manual from 1927, I believe. I'm going to be reading the citizen section on that also. So, to continue, before I start, I wanted to show something. And this is why I don't really have open mic conversations on no one. Because here I am doing videos for everyone to pay attention to and to read and so forth. This citizenship video that I made last time, right? 36 views, and on average, only 4.5 minutes of an hour and 14-minute long video. Now, one, I do not care about this YouTube channel in any way. I'm not looking for followers or anything. This is just to simplify, right? Teaching you guys. Because it's not me that needs this. Okay, so this right here is disappointing. There's nothing more I could say to it. That right there is disappointing. So for whatever that's worth, and to each their own, right? But the ones who chose to read 30 minutes, 40 minutes, right? Man, contact me on Telegram. I'm proud of you. You made it through. So, to continue, I'm going to go on this law review, this law journal. So I'm going to start. So long as nations retain sovereignty while persons move or engage in transactions across geographic boundaries, the solutions of many legal problems will require concepts hinged on the relation of individuals to governing states. The purpose of the ensuing discussion is analysis of the key terms involved in determining the international status of persons: subject, citizen, national, and permanent allegiance. First section, subject versus citizen. Before the Declaration of Independence, subject and citizen were the most frequently used in the United States in connections where citizen would now be the proper word. This was the natural usage in what then were British colonies endowed with all the trimmings of the British legal order. Even after the Declaration of Independence, some states enacted constitutions designating as subjects the status of which others identified by the term inhabitants, while still others used citizens and subjects indiscriminately. Subjects of the United States were referred to in the treaty signed by the Continental Congress with France in 1778 and the Netherlands in 1782. Let's see, annotation number 2. In English law covered the status of alien-born individuals who had been naturalized by letters patent of the king. They were English subjects, and they called them I would chop that up right there. Donatu, or something like that. Hence, denzian. The right of the crown to grant letters of denization, right, which is naturalization today, subsisted after British Nationality and Status of Aliens Act of 1914. Let's see, section annotation 5. It's the agreement between the Netherlands. This agreement between 2 nations with republican forms of government referred on the one hand, to the subjects and inhabitants of the United States of America. On the other hand, to the subjects of the said states general of the United Netherlands. However, the Treaty of Paris on September 3rd, 1783, marking the official termination of the war between this country and Great Britain, contained a discriminating terminology on the point involved. It referred to the subjects of Great Britain and to the citizens of the United States. So just different terminologies for different forms of government. Although the term citizen appears as early as 1777 in the Articles of Confederation, the use of the subject as a synonym did not become obsolete before the enactment of the federal constitution. So that means that the word subject was still being used at the time of the constitution, even though the constitution used the word citizen, and the federal Articles of Confederation did too, which referred to citizens exclusively both in relation to the United States, which of course that's the government, and to the several states. That's to each individual states. This change of usage resulted from an emergent political philosophy which abhorred any tinge of colonialism. The term subject was brushed aside as a leftover from the feudal law, where it referred to the vassals of a lord bound by a duty of allegiance to respect him as their master. However, one of the ingredients of the feudal theory of subjection survived. The concept of allegiance still forms a tautological part of our statutory definition of nationality. So not citizenship, but of nationality. Annotation number 6, Articles of Confederation, precursor of Privileges and Immunities Clause of the present federal Constitution. Covering the privileges and immunities of citizens of the United States as distinguished from privileges and immunities of citizens of the several states. See Newman versus Forgotten Right of the United States Citizen. I do not have these law reviews. I will go get them because there are actually two of them. So this is volume 39, Illinois Law Review, 1945, and I'm guessing page 367. And there's another one here for 1941. No, not that one. It's down here. There's two of them here. The general temper that each epoch is characterized by perhaps apocryphal story of the plan to abandon English as an American language, and why they got rid of the words and stuff like that, and feudal language and whatever. The revolutionary attitude toward the feudal law is exemplified by the statement, since the promulgation of Christianity, the two great systems of tyranny are the canon and the feudal law. So they're talking about the canon of Christianity, the Roman, the church, and feudal law itself. The tendency to abandon feudal concepts in this field was not limited to America. The terms, I'm going to chop these up. Citoyen and cittadino, respectively constituting the French and Italian versions of citizens, supplanted subject in those countries with the qualifications discussed above at note 40 or below note 45 and related texts. In Austria, Untertan or subject was replaced by Staatsbürger, which means citizen. However, the phrase Subjectsmixel, right, which is mixed subjects, at least in European technical usage, and probably also in this country, is the preferred designation of status of persons with multiple nationalities. Number 10, allegiance is the tie or ligament which binds the subject to the king in return for the protection which the king affords the subject. The name and the form are derived to us from our Gothic ancestors. This is Volume 1, Blackstone Commentary, page 366, and also see Calvin's case. Where it is said with reference that as between the sovereign and subject, there is duplex. This is a Latin term. Duplex et reciprocal. I'm going to chop this up. I'll leave that up to you guys to read that whole phrase. Follows then the famous passage. Therefore, it is truly that protectio transhit sub. I'm not even going to pronounce that. The orthodox theory of the reciprocal connection between allegiance and protection, although of doubtful reasoning, is vindicated in the otherwise startling doctrine enunciated in the treason case against Lord Haw Haw. To continue. The term citizen supplanted subject in this country and others, although not in Great Britain, by a process of lexicographic delineation. Even in the period immediately before the American Revolution, there was no such difference in connection between subject and citizen, as would predicate reserving the status of citizen to the people of a republic and subject to those under the sovereignty of a monarch. Distinguished French lawyers writing during the Ancien Regime seem to have found nothing preposterous in their occasional use of the term citizen with regard to the most absolutistically ruled subjects of the King of France. During the Middle Ages, citizens lived in towns, and so were members of communities exempted from the then almost ubiquitous feudal system. But when the medieval system of government was replaced by the principles of territorial state sovereignty, subject and citizen became the use as synonyms, at least by such eminent writers as Bowden and Gratuitous. See what they say. In Baumgartner versus the United States, 1944, after citing Schinderman versus the United States, 1943, and similar cases, allegiance is to this government and its laws is a compendious phrase to describe those political and legal institutions that are the enduring features of American political society. We are here dealing with the test expressing a broad conception of breadth appropriate to the nature of the subject matter, being nothing less than the bonds that tie Americans together in devotion to common fealty. Also see section 68 that's still coming up. Annotation 12, see section 101A of the Nationality Act of 1940. I give you the stat and where it was located in Title 8. The term national means a person owing permanent allegiance to a state. That's the same definition that they have now in 1101. In 1101, what is it, number 21? Elucidates the term national of the United States means 1, a citizen of the United States, or 2, a person who, though not a citizen of the United States, owes permanent allegiance to the United States. So in this context, for this definition, the term national of the United States means 2 things. It means national, like they just stated, and it also means a citizen of the United States. It does not mean, 3 things or whatever. It does not include aliens. Right? The final phrase is cryptic. If alien means one who is not a national, the phrase is superplusage, meaning it's wordy. They didn't have to add it. If alien means one who is not a citizen, it is inconsistent with the fact that the act establishes the possibility of nationality without citizenship. A guy named Query, or whatever that term means, Is there any third way of understanding the phrase? So that's a question. British subject, annotation 13. British subject is an inclusive term, denoting all subjects of His Britannic Majesty, to whatever part of the Commonwealth they may belong. The term citizen is applied to a person in respect to whom a particular member of the Commonwealth claims jurisdiction. The rest of them are going to be references to other books. Different uses, and they just tell you the difference how other places have used the words, the different words. What was it? Although others, including Pufendorf and Spinoza, obviously inspired by a passage of Aristotle's Politics, attempted to re-establish a distinction between the two forms. That's 18, 19, and 20, right? Perdinov, they give you a reading, which I don't have none of them. That would be in a different language anyway. Spinoza says, we call men citizens as far as they enjoy by the civil law all the advantages of the Commonwealth, and subjects as far as they are bound to the ordinances or laws. Number 20, a citizen is defined by nothing else so much as by the right to participate in judicial functions and in office. The definition of a citizen that we have given applies especially to citizenship in a democracy. Under other forms of government, it may hold good, but will not necessarily do so. For the impact of this definition, they're telling you to look up this. See also Scott law, state and international community. Number 25 is another. That's under here. All right. Spinoza's abstractions remained without direct practical effect until the passage of Rousseau's social contract, adapting and somewhat coloring, but not quoting Spinoza's proposition, provided the stimulus was made, which made citizens the terminology for self-governing people. An English version of the passage reads, with regard to the associates, they take collectively the name people, and are individually called citizens, and as participating in the sovereign power, and subjects as subjected to the laws of the state. And they give you more to read. They don't give no good reading. Next section. Nationality as the status of belonging to a state. Nationality is a young word. Its matrix and French national appeared for the first time in 1835 edition of the dictionary. This is French, so I'm going to chop this up. Dictionnaire der Académie France, right? So I'm thinking of dictionary of the French Academy. It has at least two separate accepted designations. One, the status of belonging to a state. Two, the quality of membership in an ethnological group. Nationality, in the sense of belonging to a state, is a primarily legal concept, the existence of which in a certain person will be determined by such intrinsic test as the applicable law prescribes. So to go off this, number 20, section 25, annotation 25. This duality of meaning derives from the parent word nation. Contrast the answers to the question, what is a nation? The French revolutionist Abbé Sieyès, as quoted by Subak, National Consciousness, 1943, page 63, answered, a body of associates living under one common law and represented by the same legislator. He obviously pointed to statehood. It continues down here. The existence of a nation is a daily plebiscite. He certainly meant nation in the ethnological sense of the word, as did Shakespeare in Shakespeare's Shylock. He hates our sacred nation. The Merchant of Venice. So they're quoting Shakespeare right there. Where did I leave off at? Nationality. Yeah. Nationality, ethnologically, while essentially a sociological conception with political implications, may occasionally have a palpable legal effect. Determination of ethnological nationality in a given case may be a touchy matter since the standards are not universally recognized and are at least partly subjective rather than objective. The reason why is what? Every single country, every government for every country throughout history has defined this term and the qualifications that make it so. In its legal sense, the term national is often used as a general designation, irrespective of whether the status of belonging to a state is examined with a view to certain rights and or duties under international law, or is looked upon as the basis of rights and duties effective within the domestic sphere of a state. However, the trend is to reserve the term national for the designation of that status by virtue of which a person internationally belongs to a certain state, and to speak of citizenship when the local status referred to is one of the domestic rather than international. Let me read this annotation. Nationalism may perhaps be described as the dynamic trend of a nation in the ethnological sense of the word to become a nation in the sense of independent statehood. This is a commentary under the Austrian Constitution. So they give you worldwide interpretations. These are principles that are being expounded in this law review. Next section, citizenship versus nationality. Citizenship in modern usage is not a synonym for nationality, or a term generally used for the status of belonging to a state, but means specifically the possession by the person under consideration of the highest or at least of a certain category of political rights and or duties established by the nation's or state's constitution. This means what? Its powers, its rights and privileges categorized within the classification of a person. These are things that you possess, meaning you, the living man, step into that form of an office called citizen, and that citizen possesses all these attributes. That's what they're saying right here. And this should be in agreement with the gentleman from the other that Telegram group who was talking about the military manual. These are rights that you possess, that you do possess. It is not a thing in and of itself. This conception, substantially amounting to a modern revival of Aristotelian formulation, is defined by Moore. Citizenship, strictly speaking, is a term of municipal law and denotes the possession within a particular state of full civil and political rights, subject to special disqualifications such as minority or sex, just like what the 14th Amendment does. The conditions on which citizenship is acquired are regulated by municipal law. However, since the list of the concrete rights and duties that constitute citizenship in this specific sense differs according to the country in question, it has also been said there is no universal definition of citizenship when citizenship ceases to be synonymous with nationality. And that's exactly what happened. They separated the two. The reason why is because conquerors, right? Countries that became conquerors, those persons that they conquered, the countries that they conquered, those people within were not citizens, just like in Roman law. They were something else that were beneath them. They did not receive the full strength and the full powers possessed by citizenship, which is what a national is. Applications of citizen in the narrower case along the lines of Moore's definition have occurred chiefly in connection where the domestic status of nationals vary. The Mexican law apparently considers such special disqualifications as are inherent in minority as inconsistent with the concept of citizenship as distinguished from nationality. In the United States, there has been an issue as to whether the so-called alien vote, which for a time existed in certain states, it doesn't really reference if it's an illegal alien vote or not, was tantamount to the possession of citizenship, a question which seems to have been finally decided in the negative. That means they took it away. States didn't have that power. To read annotations, 28, an outstanding German monograph of the modern distinction between nationality and citizenship is Lessing, and this is all German. So they're giving you a reference here. Law of Nationality and Naturalization, 1934. In order to be a citizen, a Mexican must be over 21 years of age, if not married, and over 18 years if married, with a further requirement in either case that he possesses the means of a decent living, meaning that you are not a what? A pauper. Here, in the Constitution, and this is going to be court cases, right? The privileges and immunities for state citizenship apply to all free people living within the state, right? But there's exceptions to it, and they call them vagabonds, paupers, and fugitives of justice. Paupers are people who cannot support themselves. This is why one of the provisions for naturalization, right, the requirements is what? Someone being able to support that person that's coming over, vouch for him. Or that person who's coming over has to have what, $10,000 or something like that at the time when his application is being processed. The alien vote existed as late as 1926 in Arkansas. I would like to read this because I would like to know the concept of this in regards to what's happening today and that they're trying to legalize voting for these illegal immigrants. It's one thing if they're aliens, it's two if they're not, if they're illegal aliens and they're residing here, right, illegally. For a contemporary survey of the various state laws on the alien vote, see Burnham, The History of the Law of Aliens from the Standpoint of Comparative Jurisprudence. Where did I leave off at now? I was tantamount in the possession. Okay. A similar dispute arose regard to a somewhat reverse proposition, namely that since women may be citizens in this country, they should as such be entitled to the suffrage. While the Supreme Court of the United States decided the negative, right, because the Constitution was not written for women, right? An amendment to the federal Constitution satisfied the claim of the feminist, right? And this is because the 14th Amendment, right, they allow discrimination. Well, one, they allow discrimination against women. Two, the word person includes the word woman. They don't state them specifically, but it states them. So that's why the amendment later on was passed, which was what, Amendment 19. The first precedent in the line of Republican constitutions which use the term citizen substantially in the narrower case seems to be represented by the French constitutions of 1793, 1795, 1799, which, in contrast to the French Constitution of 1791, distinguished between a Francis generally and citoyen. So I'm guessing there's a difference between these Francis and citoyen. The latter term designated the Frenchmen who possessed the qualifications prerequisite to the vote. Citizenship in this sense was also mentioned in the original Code Napoleon. For a time during the 19th century, there was a tendency in France to distinguish between two kinds of naturalization. Grand naturalization conferred the legal possession of citoyen. Petite naturalization made the former alien a Frenchman without the right to vote. And this is what? This is what we would call naturalization. But this right here is they don't even have the right to vote, where in naturalization today, they do have a right to vote. In this country, limited distinctions exist between the status of born and naturalized citizens, in that only a born citizen may become president or vice president of the United States, while a naturalized citizen may expatriate himself by extended residence abroad. So here is a penalty. They have it that if you are a naturalized person in the United States and you leave and go somewhere else, and if there's a certain time period, and I think in this country it's 5 years, you will be considered a non-resident and you won't be a citizen no more. But the term or this concept is a presumption, a rebuttable one. Because for you to lose citizenship, whether you were born here or naturalized, your intention to leave is paramount and a requirement. Let's go, and if you want to read the court case about the judge with woman as the right to vote and stuff like that, this is the case Minor versus Happersett, 21 Wall 162, 1874. And I think that was before Susan B. Anthony. I'm not sure. I think Susan B. Anthony was like 1879 or something like that. Prior to the amendment of 1889, Article 8 referred simply to a Frenchman, while Article 7 referred to the capacity of a citizen, qualité de citoyen, and provided that the exercise of civil rights should be independent therefrom. In view of the influence of French law upon the legal developments in Latin American countries, it is fair to assume that constitutional provisions in those countries which employ the term citizen in a narrower sense may be traced to the French constitutions. So they restricted the word citizenship to exclude those other people who were not being born here, or was birth on the land and birth by blood. In the end, that's ultimately what it constitutes. Section. This is annotation 41. The Nationality Act of 1940 provides for loss of nationality by naturalized Americans who reside abroad for extended periods under specified conditions. The previous statute created only a rebuttable presumption of voluntary expatriation. Such loss of nationality should not be confused with revocation of nationality under Title 8 under that section, where naturalization was frequently procured. By Section 7338C, removal abroad within 5 years of naturalization is prima facie evidence of a lack of intention at the time of naturalization to become a permanent citizen of the United States. The constitutionality of the current provisions for loss of nationality has not been passed on by the courts, and earlier cases dealing with the cancellation of naturalizations under older laws are not necessarily in point. For a discussion of the problem as stood before the Nationality Act of 1940, see Flournoy, Revision of Nationality Laws of the United States. And then they got a handful more. Actually, it's the rest of this. Recommended readings. Annotation 44. The rationale is that the backward people must be educated to the art of self-government. Kelson is one of the earlier works considered this gradation inconsistent with democracy as then defined by him. And this is what? Nationals, right? So when they conquer other lands, right, they see those people as backward people and uncivilized and must be educated to acquire the art of self-government. Hitler's Secretary of State for Interior, Starkart, suggested as an anti-Semitic device the Nuremberg Laws, which established a gradation among those who were simply Staatenborgen, I'm chopping that up, or nationals of the Reich, and those who possessed the racial qualities which were required for the possession of the privileges of the privileged status of Reichenberger or citizen of the Reich. These laws substantially duplicated the 16th century Spanish enactments instigated by the Inquisition, which made the possession of Christian blood a requirement for the status of civis pleni juris, or full citizenship. I'll read these annotations too. Which was down here. Oh, well, I did read them. So never mind. Citizen versus colonial subject, the American non-citizen national. An application of political ethics not to be confounded with racial discrimination is a gradation of nationality employed by a country standing on a high level of civilization which attaches to its sovereignty a territory with a backward population. Attaches to its sovereignty a territory like Puerto Rico, like Guam, American Samoa, right? What else? The tribal lands, right? Indian reservations. Right? To avoid granting the letter of full share in self-government of the former. For this reason, France and Italy distinguish between citizen and colonial subject. The Nationality Act of 1940 sanctions the distinction between American nationality, including American citizenship, and American nationality devoid of American citizenship. So the distinction between American nationality, including American citizenship, and American nationality devoid of American citizenship. So there's two things here. In terms of this statute, American citizenship embraces, in addition to those privileges and or duties which are inherent in American nationality, such as the possession, the possibility of diplomatic protection by the United States, and the body of obligations customarily referred to as permanent allegiance. The existence of those rights which only a citizen enjoys under the Constitution. However, even recent legislation occasionally used the term citizen in a wider sense, embracing any American national. Again, however, even recent legislation occasionally uses the term citizen in a wider sense, embracing any American national. Let's read these up to 49. So, number 45, they don't give you nothing except further readings. Here's 46, and this is what I posted in a few groups on Telegram. It says, and it also tells you, see note 12 above, right? In Mixed Claims Commission, United States and Germany Administrative Decisions and Opinions to June 30th, 1925, Administrative Decision number 5, 1924, page 193, the following rule was laid down. So this rule was laid down specifically in this context, and it only applies in this context for whatever laws were created from this context. Can't stress that enough. The term American national means a person wheresoever domiciled owing permanent allegiance to the United States of America, and embraces not only citizens of the United States, but Indians and members of other aboriginal tribes or native peoples of the United States and of its territories. Now, what they just stated here is a principle of a term that encompasses all of these. It encompasses citizens of the United States. It encompasses the nationals of the United States on these territories. It encompasses Indians. It encompasses everything. So what could change this definition? And if one of you study trust law, it is you who changed the definition. You, when you create your law for the property that you govern, you change it. So that's what they did in the Constitution and in the statutes that follow. However, protection may always be extended or withheld at the discretion of the Secretary of State. And you got to read the specifics. Revising Our Nationalities, 1934. See section, page 67. Citizen, as used in the Neutrality Act of 1939, included any individual owing allegiance to the United States. Think about what they just said here. For the purpose of this statute, the word citizen included any individual owing allegiance to the United States. So that means on the territories. It meant everybody. Within the meaning of a particular statute, Filipinos, otherwise non-citizen nationals, so they were called non-citizen nationals. But for the purposes of this statute, what did they do? They broke up this principle of American national. American national, it means a citizen. And then they included them in the word citizen. It's context. Filipinos, before the independence of the Philippine Islands, are the most conspicuous recent specimen of American non-citizen nationals. It has been suggested that before a special statute made American Indian citizens, they should have been considered non-citizen nationals of the United States, and that is true. Before the considering of citizens, their consideration as citizens, they should have been considered as nationals first. And that same thing for the African race, the blacks, at this time. Let me read 50 and 51. This is Hayden, the Philippine, a study in a national development. For a recent judicial discussion, blah, 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 it says, now everyone here should be familiar with this court case. Hooven and Allison Company versus EVAT. This is the court case that was the last time that they defined the term United States. But this is a court case specifically dealing with the Philippine Islands. Need for new applications of this category may arise with regard to the population of a permanent basis acquired by this country following World War II. See also Administrative Decision number 5, Mixed Claims, blah, blah. And here, Elk versus Wilkins, 1884 case. This guy right here was born on federal territory, meaning he was born on an Indian reservation. Right? The 14th Amendment only is applicable to the states, the several states of the Union. It has nothing to do with federal territory. So in this case, he was not a citizen because he was born on federal territory. He had to leave and show intention that he wanted to leave the governing body of the reservation of his Indian tribe. And the way to do that, the only method for him was through naturalization. No different than a person from Mexico, Germany, or wherever else. I highly recommend that you guys read that case. Lawyers who, at an earlier period of American history, denied to native-born free Negroes the status of American citizens, but nevertheless held them eligible for the diplomatic protection of this country. That means what? They were considered nationals. Seem not to have realized the technical possibility of construing their status as that of non-citizen nationals. Although, with regard to declarant aliens or aliens with first papers, Secretary of State Marcy, in his note in 1853 concerning the Costa affair, appears to have raised the point that a person may be a national of the United States without being an American citizen. The prevailing opinion seems to be that declarant aliens are not American nationals, since it has been settled that they are not within this country's diplomatic protection. And those anomalies which previously singled out their conditions from that of other aliens no longer exist. So the prevailing opinion seems that the declarant aliens are not American nationals, since it has been settled that they are not within the country's diplomatic provision because they're aliens. They still have allegiance, right, to another country. They haven't made an intent yet. But to read these 52 and 53, and they give you the Dred Scott case, which people should read. This is paraphrasing the Secretary of State Marcy. In the view of high judicial authority, persons of African descent could not be regarded as entitled to full rights of citizenship, although the council could not certify that they were citizens of the United States. He might certify that they were born in the United States and were free, and that the government would regard it as a duty to protect them if wronged by a foreign government. And that's why ultimately why the government stepped in and then gave them citizenship. They removed that nationality aspect of it, the national aspect of it, with the 14th Amendment. All persons born. All right, next section, permanent allegiance. Reference to a duty of permanent allegiance is not a happy way of defining nationality in the sense of status under international law. Such a definition envisions a specific distinction between the permanent relation of nationality and the temporary allegiance required of resident aliens, and so keeps alive the largely abandoned maxim, once a subject, always a subject. However, a national can now generally expatriate himself, at least by naturalization in another state. Most states make such denationalization automatic, while the existence or absence of such a provision is generally a matter of domestic law. The so-called American doctrine of voluntary expatriation in effect postulates loss of original nationality on naturalization elsewhere as a principle of international law. The American doctrine was substantially, if not in terms, enforced by the Franco-Turkish Mixed Arbitral Tribunal after First World War, although not granted acceptance at the Hague Conference of 1930. So let's go back up and read these other annotations. So this is going to be 59, 57, 58, and 59. Where expatriation is explained as the voluntary renunciation or abandonment of nationality and allegiance, thus apparently separating allegiance from nationality. Where the doctrine of allegiance was applied to an alien possessing a fraudulently obtained passport issued by the sovereign claiming allegiance. England abandoned the feudal concept of dissoluble subjection by legislation in 1870, where it is said that permanent allegiance as a technical term for the tie between a state and its nationals does not mean that the tie cannot be severed, but that so long as it continues, it exists whether the national is for the moment in the territory of his state or not. That means he has to make an intention to get out. So even if he goes abroad, it don't change nothing. All he did is go abroad. There's no intention saying nothing else aside that he traveled somewhere. Let's go number 60 to 64. They just more recommended reading for 60, 61. This is sometimes called the French principle because its first statutory enactment was contained in the French Constitution. 62. The American policy found the most forcible legislation expression in the Expatriation Act of 1868. And it was codified statute, that's large 15 statute 23. Partly quoted by Kostler, this act has not been abrogated by the Nationality Act of 1940 for the recent repeal of similar provisions in the Mexican legislation. More stuff to read. More stuff to read. All right. The term allegiance in itself has become archaic. In its feudal setting, allegiance denoted a reciprocal correlation of interconnected rights and duties. But in modern states, the obligations of a national to the nation are unconditional, rather than contingent upon the state's compliance with corresponding duties. Only in isolated instances do modern writers consider the relation between the national and his state as contractual. Furthermore, the national of a state is generally not entitled to claim protection as a matter of right. The state has a right as against other states to exercise diplomatic protection in his behalf, but not a duty towards the national. Let's read these first before I continue. Number 66. An apparent exception to Article 112 of the German Weimar Constitution reads, all German citizens within and without the boundaries of the Reich have the right of the protection of the Reich against foreign countries. And this is ultimately why they invaded Poland. It doesn't matter what happened after World War I and that Germany lost land. The people were still bound to the German nationality. They never rescinded their nationality. They never had an intention to. This provision was literally taken from Article 3, Section 6 of the previous German Constitution, the Imperial German Constitution. Discussed that's in this one, that German word. Okay, this provision was literally taken from, all right, I read that. Laban believed that Article 3, Section 6 of the Imperial Constitution was a right technically of the German citizen against the right. And then they even give you, look at slaughterhouse cases, even though they're talking about German stuff. Because it's a principle that they're trying to expound here. I'm not telling you something on a specific concept. It's a principle. In this country, a definite practice has been established that in certain typical situations, diplomatic protection should normally be denied in spite of the American nationality of the applicant. Deprived of one of the essential ingredients which went into its feudal meaning, namely of the subject's right to claim his lord's protection, and also minus the whole general background of the one-time feudal society, permanent allegiance, referred to in modern definition of nationality, cannot be more than a synonym for nationality. So now they're telling you that permanent allegiance is just nationality. Because the permanent allegiance aspect, right, where you couldn't leave nowhere, right? Back in the feudal society, it ain't like that no more. You have the right to expatriate at any time that you want. But it is a permanent allegiance during the time of as that you are a national. It has become a mystic concept which dims instead of clarifying definitions. Most people have a working knowledge of the meaning of nationality, but even scholars are at a loss to explain allegiance. Characteristically, the Harvard research on nationality suggests defining nationality as the status of a natural person who is attached to the state by a tie of allegiance, and then models the picture by saying, no attempt is made in this draft to define the meaning of allegiance. It may be observed, however, that the tie of allegiance is a term in general used to denote the sum of the obligations. Right? So these are possessions of some rights or powers or obligations, right, of a natural person to the state to which he belongs. It's a person. That's how it is. It's a person that you step into. And you could leave those shoes, that hat, or that office at any time. The draft itself does not spell out these obligations since they are quite different in different societies. It seems desirable to eliminate allegiance from any technical use and redefine nationality in plain words, meaning the status of belonging to a state for certain purposes of international law. So let's read these annotations. Under this, annotation 68, under this assumption, definitions of nationality which explain the latter by referencing a permanent allegiance are tautological as suggested on the first page. But they are, in this respect, not worse than some definitions not referring to allegiance. The other ones are additional reading, annotation 71. In passages where the English text of the Treaty of Versailles referred to nationals, the French one did not always use the term national, but sometimes synonymously employed the word, I'm going to chop that up, restaurants, ressorlions, which means belonging to. Therefore, it looks like a German, in the Friedverstag, 3rd edition, 1923, challenged the correctness of the occasional attempt to distinguish in the application of the Treaty of Versailles between national and ressorlions, right? National and ressorlions. Another source of confusion in defining nationality is the concept of state sovereignty is personal as well as territorial. Let's read 72 right now. Of course, these two kinds of jurisdiction are merged into one in the case of nationals residing within the national territory. The right-duty relationship between states with respect to a national of one is a function of the personal sovereignty of the state over its nationals. However, the distinction between personal and territorial sovereignty are flexible and not clearly delineated, so that this concept does not contribute to defining nationality as an aggregate of specified rights and or duties. I'll give you an annotation, last one for that section. How far a given state intends to stretch its personal jurisdiction or sovereignty with regard to nationals abroad is a matter of domestic law. Whether its respective claim is justified in relation to other states in a matter of international law. Illustrative of the claim of an American domestic law concerning the extent of personal sovereignty of this country over citizens abroad. Let me give you a U.S. Cook versus Tate, 1924. It's a taxability case. And one concept is this, right? Say that you function in such a way in your life that you don't ever use the national character of U.S. citizenship in any of your dealings in life. Everything is within the state that you are living in, right? But if you go abroad, right, you are and do fall under the category of a U.S. national. But under U.S. national, the concept of United States citizen, you are protected by the federal government in this context, not by the state that you are from. It's important that you understand that. Nationality as a formal category. Nationality is a formal legal category consisting in a person's status of belonging to a state. Error seems inherent in any attempt to define the conception by reference to allegiance or to any other specific right-duty relationship, inasmuch as rights and or duties which are attributed to the status of national, whether by international or domestic law, will vary geographically and temporarily. The concept of nationality is no more than a formal frame surrounding a picture of changeable character. For example, the most conspicuous international function of the nationality concept is the right of a state to extend protection of its nationals abroad. In exceptional cases, a state is permitted to exercise protection over individuals, not its nationals. Or conversely, it may be excluded from the right to protect those of its nationals who belong to a particular category. So let's read these annotations here. 73. Oh, I read that one. 75. This is one of the errors in Lessing's definition of nationality as the relation between an individual and a state by virtue which the latter is entitled to protect the former abroad and is bound, which the latter is entitled to protect the former abroad and is bound in addition to permit his residence on its territory with the resulting prohibition of banishment of a national from the whole national territory and the resulting duty of receiving back a national deported from a foreign state. Nationality as distinguished from citizenship in the narrower sense, right, because they shrunk it down. They shrunk it down for the purposes of birth by land and birth by blood. That's what you need to understand, the narrower sense. And in our case, it's birth on the land within any of the several states of the Union. Birth by blood, it doesn't matter where you're at in the world. Though primarily a conception with an international function, it often borrowed as a convenient attachment for certain strictly domestic purposes, as in statutory provisions making nationality a requirement for admission to certain public offices of quasi-public or even private professions. In this connection speaks of accessory effect of nationality, i.e. secondary. 78. One of the most important and delicate of all international relationships, recognizing the immemorially as a responsibility of government, has to do with the protection of the just rights of a country's own nationals when those nationals are in another country. What did I stop at? But normally, it is only through the intervention of a state of their nationality that private persons are able to obtain redress against injuries inflicted upon them by a foreign state in violation of international law. However, there is a trend toward permitting private persons to raise international claims without intermediate agency of a state. Materialization of this proposition would render the institution of diplomatic protection obsolete, if not formally abolished. But nationality would remain a living concept as long as legal consequences are attached to the status of belonging to a state. As a further example, it is sometimes said, either unconditionally or with qualification, that a country is prevented by international law from forcing military service upon nationals of another state. The validity of this statement appears doubtful in view of numerous and important precedents to the contrary, assuming a restatement to harmonize international law with the practice of states which draft certain categories of aliens' nationality, though no longer implying the national's exemption from military service for a foreign state, would retain conceptual utility. Let's go all the way to 83. 80. It is unlikely that any international tribunal would have recognized a Nazi claim of an alleged right to protect German Jews abroad. It is unlikely that any international tribunal would have recognized the claim for the right to protect the German Jews, because they weren't even protected in the state that they were nationals from. They were violating international law. Said the Permanent Court of International Justice in its judgment on February 1939 concerning Poneze's, I'm chopping that up, railroad case. In the absence of a special agreement, it is the bond of nationality between the state of an individual which alone confers upon the state the right of diplomatic protection. They give you more to read here. Only states may be parties in the case before the court. 84. A frequently cited dictum is the advisory opinion of Permanent Court of International Justice, 1923, in the case of Tunis, Morocco nationality. There's just additional reading. It says, there's a substantially identical statement in the court case United States versus Wong Kim Ark, which all of you should be familiar with. That is the case of Chinese nationals, because they were not citizens of this country. They were here, permanently residing here, but they were not citizens because there was a statute prohibiting them citizenship here, because they were not born here, right? So to become a citizen here by not being born here is a privilege, right? So they were permanent residents and nationals of China who gave birth to a son here. just under the principles of the 14th Amendment, all persons born made the son an automatic citizen of the United States. Now, whether he's a citizen or of China, that's up to China to decide. But he probably is a national of China under international law in comparison to what we just read, or in respect to what we just read. The British Yearbook of International Law suggested that international law by, I'm chopping that up, blank catechise, assigned the determination of the nationality status to the several domestic laws, further reaching than those attempts at harmonizing the domestic domain principle with the general system of international law, rather challenging the validity of the rule itself, is the following statement by an otherwise unorthodox British writer. It is sometimes indeed laid down by authors in general terms that a state has a right to say who are its subjects, but it is hardly necessary to demonstrate the absurdity of such a proposition, because it should be a given. A common sense of nations obviously limits the power of a nation to seize at pleasure the subjects of other states as its own. How far are we going? To 87. I'm going to chop this up. It's German though. Imagines of hypothetical case of an Austrian law declaring all Chinese resident in Peking, which is Beijing, to be Austrian nationals. So here, the Austrians, right? They recognize Austrian nationals, meaning their own people being born somewhere else, and so forth, or naturalized some, or whatever the case may be. It will be dependent on that, but nonetheless, it's a recognition. Submits that a state could hardly be entitled to enforce its own courts as against its neighbors some peculiar doctrine of nationality which was in conflict with the general and customary rules of international intercourse. For example, an attempt by an English king in the 17th century to give effect in the traditional claim of English monarchy to the crown of France. The same book suggests that it would have been against international law should Great Britain, in her Naturalization Act of 1870, have conferred British nationality upon all persons speaking English in their native tongue. He even ventures to guess that such legislation would have been followed by a declaration of war by the United States, which it's good. I mean, just because they speak English doesn't make them one of theirs. It's just a language. It's a characteristic of a people. And those people could be spread out across the world. All right. Well, maybe I should not have kept on reading. I should have just stopped here. International function of the nationality status versus its domestic determination. And this is probably pertaining to most of us in these groups talk about or have issues recognizing the context of. According to the principle of domain reserve, the acquisition and loss of nationality is determined by domestic rather by its international law. Of the numerous complications that may result from this principle, the most important revolve around the man without a country and the sujet mixte, meaning multiple nationalities, I think. These anomalies are frequently caused by divergence between just solely and just second. See, this is by right of land and right of blood, concurrently applicable to the same individual pursuant to the principle of reserved domain, which in this respect would seem to become self-defeating. For example, an individual born in a country applying jus sanguinis, right, birth by blood, of parents who are nationals of a country applying birth by land would acquire neither the nationality of his country of birth nor the nationality of his parents, but be born as a stateless person. Conversely, an individual born in a jus soli country of parents who are nationals of a jus sanguinis by birth, by blood, country would be born with the embers de richness, possessions of two nationalities. Double nationality may also be caused by the divergence between two domestic laws, one of which still sticks to the old rule, once a subject, always a subject, while the naturalization practice of the other disregards that maxim. So I'm going to go read these. Shouldn't even be reading all these. We're going to start at 84. A frequently cited dictum is the advisory permanent. Oh, I already read that. I read all this. So I read annotations before I read the actual sections. So we're going to go right here to 86. Man without a country, as used here, means a technically stateless person and not one in the situation of the central figure in Edward E. Hale's story, The Man Without a Country. I would like to get that book, 1863. It says also see Secular Hudson Statelessness. And that's like it said, it applies. Like if China only has a law that only birth on the land, right, and that's it, not by blood, meaning that if you're anywhere else in the world, you're not a Chinese citizen or a Chinese national just by blood. Then them being born here, they don't get nothing. They don't get nothing from China. But that's, like I said, that's an assumption, an example. Roughly described, jus soli attaches the nationality status to the fact of being born in a country. Jus sanguinis to the fact of being the son of a national. In this country and some others, a mixed system prevails, as appears from the inspection of the Nationality Act of 1940. I gotta read 89, and they just give a citation to read. And this is taking longer than I wanted. The domain reserve principle in matters of nationality law also implies that whenever, by international custom or treaty, certain rights or duties of a state with regard to a given individual flow from the latter's condition of belonging to that state, a different category of people will be included according to whether the domestic rules concerning the acquisition of nationality are governed by the jus soli or the jus sanguinis. Qualifications of the domestic domain principle have been treated by way of bilateral as well as multilateral treaties. The existence of qualifications other than treaty provisions has been alleged by various sources, but always in a vague language which does not represent a workable rule of practice. Disregard of the principle in cases where its practical consequences would be absurd could be technically justified by recourse to the public policy clause or, public order exception, ordine public exception, which appears to be applicable beyond the sphere of the conflict of laws in the domestic field. A similar line of approach is suggested by those who point to the legal reaction against abuses of the right of sovereignty. So up to read annotations to 93. So 90, outstanding among the latter is the Convention on Certain Questions Relating to the Conflict of Nationality Laws, 1930. However, only a few states, not including this country, have declared their adherence to it. See memoranda submitted by various governments. So this is all additional reading. Recently, an author went to the extreme of submitting a rather casuistic list of types of attachment which he believes are the factual substantum required by customary international law as a condition for the validity of domestic law, conferring the respective state's nationality upon a given category of individuals. On applicability of the public policy clause in the field of international law, and it gives you more to read. What do they say? Number to 93? Yeah, 93. So this is French. I'm not even going to read that because I'll chop that up. 1925. The German Civil Code, section 226, very narrowly defined as an abuse of a right, an exercise thereof which is done for the mere purpose of doing harm to another person. Domestic courts in several cases have shown readiness to disregard a foreign municipal law under which a self-exile, in spite of his own declared intention to the contrary, would retain his nationality of origin. Moreover, there have been cases where an individual who has lost the nationality of a state under the latter's domestic law was by a foreign court still considered its national. Similarly, the Expatriation Act of the United States of 1868 seems to announce the principle that this country will disregard any foreign nationality law under which an individual, irrespective of his American naturalization, still retains his nationality of origin. And you got to understand, this right here is context. It's all about context. These words, these terms are being defined within this scope. It's not general in nature. Or it's not general in its scope, right? Some water. A general exception to the rule of domestic domain in matters of nationality law is represented by the prohibition of compulsory naturalization, which, according to textual authority, forms part of the prevailing customary international law. This prohibition means that no state is allowed to confer its nationality upon the nationals of another state unless the individual himself asks for such a change of his status. So just because you visit somewhere, they can't make you become one of them. Reference may in this connection be made to the protests which the United States in several instances raised against Latin American laws that had introduced automatic naturalization for certain classes of aliens. The affected countries gradually eliminated those offensive statutory provisions. So this goes up to 100. For a comparative study, read this. Expatriation has been defined as a voluntary renunciation or abandonment of nationality and allegiance. I'm going to give you a case, Perkins versus Elg, 1939. However, the normal uses of expatriation would seem to indicate loss of original nationality through naturalization in another country. 95 is more to read. So is 96. 97, they reference a statute. 98, it was said that the Act of July 1868 affirmed the right of every man to expatriate himself from one country. The act was intended primarily as a declaration of the position of this government towards foreign-born persons which should have obtained naturalization as citizens of the United States, and thus made it clear that this government no longer recognized the ancient feudal principle of indissoluble allegiance. Its language, however, appears to be broad enough to include not only the reverse picture, i.e., an American who obtains naturalization in a foreign country, but also the case of a person expatriating himself from his country of origin without simultaneously acquiring a new nationality, but rather with a view to becoming stateless. But no authority exists covering such an extended application of the Expatriation Act. This I would like to learn more about. But also in the case of a person expatriating himself of his country of origin without simultaneously acquiring a new nationality, but rather with a view of becoming stateless. Let's see, 99 is more reading. And 100, the Reformed Nationality the Reformed Nationality Law of Mexico, 1934, dropped the provision contained in Article 1, Section 10, I'm guessing, of the former law, Lex Vioria, 1886. Under the latter, aliens acquiring real estate in Mexico and failing to make a declaration of retention of their nationality of origin thereby automatically become Mexican nationals. Under the latter, aliens acquiring real estate in Mexico and failing to make a declaration of retention of their nationality of origin thereby automatically became Mexican nationals. But they dropped this provision. I left that at 100. Customary international law has not yet developed an exception with regard to the population of a territory, voluntary or involuntary, changing its sovereign. This general proposition is probably true also in case of individuals who at the time of a foreign annexation of their home territory are residing abroad and thereupon remain abroad permanently. Let me read that again. Customary international law has not yet developed an exception with regard to the population of a territory, voluntarily or involuntarily changing its sovereign. This general proposition is probably true also in the case of individuals who at the time of foreign annexation of their home territory were residing abroad or are residing abroad and thereupon remain abroad permanently. The right of option, though often granted in treaties concerning cessation of territories, is not established by customary international law. No exception of the principle of reserved domain is represented by the fact that, especially in modern times, the practice of enemy alien treatment very often disregards formal nationality by generally exempting from the treatment certain categories of technically enemy but really friendly aliens, and on the other hand subjecting to the extraordinary regime categories of nationals who are not trusted within regard to their loyalty. In these cases, it is not the domestic domain principle, but nationality itself which ceases to be a dominant factor. Conclusion. Well, let me read the annotations first up to 105. 101, additional reading. 102, but there is authority to the contrary. It is a rule of international law that when a territory passes to a new sovereign, it must, in case of doubt, be assumed that those inhabitants of the territory in question who are not domiciled there do not acquire the new nationality. So persons who are not, so if your country gets taken over, right, or a territory, or gets acquired by another country, and you're living abroad, then at least at this time, it's not recognized that you are automatically of that nationality, which is kind of crazy because that's not what the United States did to the Japanese in World War II. They locked up everybody here, put them all in concentration camps or determined camps. It's all the same crap. 103. No. Yeah, 103. General discussions of the right of option are, and they just give you more reading. 336. No. 105. This is the comment. Alien enemies and Japanese Americans. And this is another law review. The restrictions applied to subject ethnological or other groups of citizens should not be confused with punitive measures taken against citizens who associate themselves with the military arm of the enemy government and with its aid, guidance, and direction enter this country bent on hostile acts. Well, yeah, that should be a given, right? During those camps that were created for the Japanese here, right? But they did it to everybody. No doubt there was some that were hostile against the United States, right? But not everybody was. Some were actually citizens and so forth, and they had rights that they had to be protected on. Conclusion. This article has attempted to show that nationality as a conception of international law does not mean any specific rights and or duties, nor an aggregate of either or of both, but it is a purely formal proposition. It designates the status of a persons belonging to a state with a particular reference of international relations among states concerning this person. In a world divided into states, it is the function of the nationality concept to apportion the global population among several nations. Each state has both a territorial and a personal sovereignty. The nationals of a state are those who are under its personal sovereignty that is attached to it irrespective of the fact of their physical presence at the given moment. In a world without states, or if the Cardenas Doctrine were accepted and established international law, the nationality conception would lose its above-defined present meaning. But a realistically anticipated future world will not be able to do away with the legal concept of nationality, though it may be accepted that specific rules of international law will assume paramount importance among the factors determining the acquisition or loss of nationality, thus depriving the domestic domain principle of its present controlling importance. It would also seem to be of no unreasonable guess that domicile rather than birthplace or filiation may in the future be the favored fact of attachment for the acquisition of nationality. Let's look up what this word is if it goes. Filiation. A manner in which a thing is related to or from it is derived or descended in some respect. The filiation of Old Norse manuscripts. The fact of being or being designated the child of a particular parent or parents. So there's annotations. But see the curious proposition of Issei substantially submitted that none of the specific criteria of nationality usually ascribed to the concept is characteristic or essential to it, but that their aggregate constitutes a essence of nationality. 107, more reading in German. 108, if one resolves the dualism of law and the state, if one recognizes the state as legal order, then the so-called elements of the state, territory, and population appear the territory and personal spheres of validity of the national legal order. 110, according to Brown, the Cardenas Doctrine, 1940, a special commission of Mexican lawyers has thus formulated that doctrine. Nationality as a personal status has full judicial effect only within local jurisdiction. It lacks extraterritorially, and its effects are therefore suspended in every instance when a moral and physical person moves to a foreign soil. This idea seems to underlie the cryptic question that Dante ascribed to the ghost in Charles Martel. Now say, would it be worth for a man on earth if he were not a citizen? And that's it. But I think this sentence right here, this first one is by more, right? This article was adopted to show that nationality as a conception of international law does not mean any specific rights and or duties or an aggregate of either or of both, but is purely formal proposition. It designates the status of a person belonging to a state with particular reference to international relations among states concerning this person. Well, hopefully you guys learned something, and hopefully more than anything you understand that it is a possession of rights more than an actual object itself. And if I recall, the person's name who read this citizenship manual was Zero. I can't remember, but I think his nickname was Zero. But what he stated about the citizenship, right, goes in line to the first video I made and this law review that I just read. So to each their own, who are still have negative feelings about what I just read. So have a good one. Hopefully you guys enjoyed, and please subscribe to Butterfly Monkey channel. And if you have any questions, which seriously no one has yet, because this right here is a disappointing number, 4.5 minutes out of 36 people, give or take, is sad. So have a good one, guys, and until next time. Next time I will probably be reading this one. I'm not sure yet, though. I got to see what I'm going to look up first. I'm going to read sections. And the same thing with this, the military manual. I will be reading sections. Right? And there we go. Have a good one. Damn, an hour and 38 minutes.